going to be appealed the ground against the Queen.
Yes, Mr. Gaffney.
Well, my lady, I appear with my learned friend Mr. Pennington Benson for this appellant. The Crown is represented by my learned friend Mr. Poole. My lady, shall I make the usual assumption that the board is broadly familiar with the underlying circumstances of the appeal, which raises a number of unusual and, we say, worrying matters, but I would think it most sensible to go straight to the part of the record which triggered the reopening of the case and led both to the grant of permission and to the matter raised by the committee in which my Lady Hale and my Lord Clerk were part when permission to appeal was granted. The reference to that request by the board is at page 467 of the record, but perhaps I can just remind you that you asked for full information, for us to use our best endeavours to find full information as to the basis for and the circumstances of the appellant's detention from September 1998 until January 2003, including the circumstances in which he was found fit to plead. And that was conveyed to us in a letter from the registrar, and as I say, for reference purposes only, it's at page 467 of the electronic bundle, and indeed the paper bundle, volume 2. But the part of the proceedings which are most immediately responsible for the appeal can be found at page 247.
Mr. Guthrie, I'm terribly sorry to hold you up, and indeed everybody else, but because one tends to annotate one's papers beforehand, I wonder if we could just have time to adjust them so that we've got the right ones in front of us.
Oh.
It's not your fault, but thank you. And all the rest, I'm afraid, please, because all the annotation.
I know, I'd annotated mine.
I suspect it's only two sets that have got
the wrong delivery.
boxed.
Had they got you the wrong way round?
Yes.
Yeah.
Very easily done, but it would be much easier to find one's own notes rather than the much better notes of somebody else.
Looks as if we're now rearranged.
The reference that I was going to take you to is at page 247 of the first volume. You have the paper record. It's the part of the trial immediately following the jury's verdict. You will see that the verdict is recorded at the top of that page. The jurors agree that it was their unanimous verdict. Then the Crown called an officer to deal with the antecedents, and he referred to the appellant, and over the page at 248 he gave some general information about him. If take it up at about line 16, you'll see that he was single and had no dependents. He believed in Christianity but did not attend a church. And then it was said that he had 3 previous convictions on the record, and that information was said to have been obtained from the accused himself and the Criminal Records Office. Mr. Harrison didn't ask any questions. He was asked by the registrar, do you admit having 3 previous convictions? And he said, I can't recall. The judge said, I'll remind you, on the 6th of August, you were convicted in the Halfway Tree Resident Magistrates Court and fined for, and he admitted that. The next one is for possession of ganja at Halfway Tree, same court, in July 1997, when you were fined 10 days in default. He agreed that. The third and last one, the judge said, you were convicted in this court, the Home Circuit Court, on the 31st of October 2000 for murder. And he said, yes. And the judge said, "You admit those?" And he said, "Yes." And the judge said, "Mr. Harrison," with a question mark. Mr. Harrison just said, "My lord," and the judge said, "In the light of the last conviction, I am going to adjourn sentencing this matter to one day next week, perhaps Thursday. Is Thursday convenient to you?" And if one just pauses there, it's rather difficult to say whether or not the judge knew in advance, or thought he knew in advance, that the appellant had been convicted of an offence of murder, or what he knew. But he certainly simply said that he would adjourn in the circumstances. Over the page, Mr. Harrison said, "My lord, I didn't know about any of those." And the judge said, "Well, this will give you an opportunity. I'll adjourn until next week, Thursday." Mr. Harrison said, "I'm particularly interested in the last one. It carries certain implications, but I had got the impression that the accused was in custody for several years by virtue of his illness. I thought he was, in relation to this matter, in custody from October 1999, not having been tried because of his illness." That was the impression. Indeed, the opinions of doctors were recently invoked as to whether it was a fit time to proceed. So the last one takes me entirely aback. And the judge said, "Well, I'll give you time." And he said, "Yes, I would like to research the matter both factually and legally." From that exchange, it appears that Mr. Harrison was aware of some previous mental difficulties that his client had. But it doesn't appear that he knew that there had been a previous proceeding in court, as we'll see in a moment, at which the jury had found that the appellant was unfit to plead. The matter came back as anticipated, and at 252 we see that there was a false start, so to speak, because at 10:15 the court, not everybody was there, but Mrs. Fraser, who appeared for the Crown, said, "We have two matters on the list, and this is the sentencing matter of Brown." I did glimpse counsel earlier. And then she says, I think in Mr. Harrison's absence, obviously, there was one matter to be queried. I don't know what counsel has unearthed. For myself, I've done some research, and the date on which the conviction was said to have occurred, my lord, I've seen on our files that there was a trial, my lord, but it was in respect of the issue of fitness, and it was on that same day on which the conviction is said to have occurred. My lord, it's my belief that that is what has been recorded as a conviction. I had asked the investigating officer to make some further checks at the Criminal Records Office, and indeed he's supposed to be here, but I haven't seen him, and so the matter stood down again. At that point, Mr. Harrison comes in. I should have said this is Mr. Delano Harrison, who was the silk who represented my client. And then he's brought up to date as to what Mrs. Fraser has told the court. In the middle of the page, the judge says, "Crown Counsel advised me that some checks were made into the antecedent of the accused Brown, whether there was a conviction." He said, "Yes, my lord. Might I just say at this juncture that you will recall that Mr. Brown said that he doesn't recall, and your lordship may by now have some idea of this toing and froing mentally. My lord, sir, his family, mother, father, and sisters are adamant that they know of no such trial or conviction, and their manner is such in the denial that I take their word for it." Again, it doesn't appear that he was at that stage aware of what had taken place in the past, other than having checked to see whether the conviction was properly recorded and having concluded from what he was told that it wasn't. Then later on...
He was aware, wasn't he, that his understanding at page 250 was absolutely right. And he said at line 10, "I thought he was in relation to this matter in custody from 1999 October, not having been tried because of his illness, and opinions of doctors were recently invoked." And that was indeed exactly the position.
Well, that was right, but it's not entirely clear what it means, because it was perfectly possible for him to have been on remand for that period and not having been tried because he was ill. Certainly these sorts of periods in Jamaica would not be wholly unusual for there to be a lengthy remand before trial. And what he doesn't say is, I know that he had been found unfit to plead. And it doesn't look as though he did know that, because he doesn't say that he did. All he says is that he understood that he had not been tried because of his illness. And we'll see in due course that that was all that was apparently clear. But in any event, when the matter is listed for the second time in the afternoon, he says, this is at the top of page 255, "My Lord, I stand because I would like to know where I stand." And then they go away again. His Lordship, on page 256, echoes judges all over the world by saying it is so difficult to coordinate anything in this place. You adjourn until 2:10 and people start driving in at 2:15. Why can't we be on time for anything at all? And Mr. Harrison says it's not his fault. And Mrs. Fraser says, "For the record, my lord, sentencing in the matter of the Queen and Brown, convicted in this court on the 16th for the offence of murder. My lord, there was some inquiry as to this previous conviction record of the convict, Mr. Brown. The officer, my lord, had indicated in the reading of the antecedents that Mr. Brown had 3 previous convictions. However, my lord, my own observation of the document from the Criminal Records Office, which we'll see in due course, has 2 convictions recorded and 1 instance where he'd been detained at the Governor-General's pleasure. And this, my lord, was as a consequence of a trial in respect of the accused man's ability to plea, which was conducted on the 31st of October 2000, and at which time he was ordered to be kept at the Governor-General's pleasure. And the indictment that is on my file, my lord, had been endorsed accordingly. I therefore wish to have Detective Constable Gray, and the corporal, in fact it's not him, but anyway, the officer is recalled. And we see the officer giving his evidence, and line 22, the records indicate how many prior convictions he had. 3. Can you just read out for us the dates and exactly what the records are endorsed? He was convicted for unlawful wounding in August 96. He was convicted for possession of ganja in July 97. And then, yes, number 3, murder at the Home Circuit Court, 31st of October 2000, at the Governor-General's pleasure. So is that a record of a conviction? This means that he was unfit to plea, and he was in custody, and he was released at the Governor-General's request. The judge says, well, was that a conviction? He said, it was recorded as a conviction on the sheet. It was recorded as a conviction. Yes, it was from the Criminal Records Office, my lord, but this is not a conviction. It was not a conviction. By way of trial, by way of trial. And he was found guilty, or he pleaded guilty to such an offence? No, ma'am. And then Mrs. Fraser says nothing further. In fact, it is perhaps a pity that there wasn't a bit more investigation of what was understood, because the judge appears simply to have been anxious to establish whether or not he had been convicted on the previous conviction, on the previous occasion, and to make sure that the record was correct, that he had not been. In any event,
the true facts are not in dispute now, are they?
I'm sorry?
The true facts are not in dispute.
No, the true facts are not in dispute, but it is important from the appellant's case's point of view as to what Mr. Harrison knew or didn't know when the trial took place. And indeed, it doesn't seem that, we say with respect, that there was a sufficiently clear investigation at this stage to establish what in fact had happened. The judge says at page 253, line 9, Mr. Harrison, I'll have this deleted. I had initialed the convictions, so I'll have to make
Sorry,
certain.
what page is that?
On page 259, I'm looking at line 9, what the judge was saying, and it really reinforces what I just said, that what the judge was concerned to do was to make sure the record did not show a conviction for murder in 2000. And then Mr. Harrison says that falls in line with what I told his lordship that I'd heard from his family. Corporal, I'm going to direct you to take this back to the records office and have the records amended to reflect that this was no 3rd conviction for murder. Yes, I'll have that down. Mr. Harrison says, perhaps Mr. Daly won't like this. I assume he's someone in the register office. And perhaps a letter to go along with that. That can be done. And then Mr. Harrison says, at top of 254, I confess this is the first of this kind of trial with this kind of result, non-capital murder, my lord. And I was wondering if the allocutus is done. Your lordships may recall that there was a considerable spate of appeals before the board some years ago as to the distinctions between capital and non-capital murder, which were introduced in Jamaica. It was slightly similar to the 1957 Homicide Act in England, where murders were divided into those which attracted the death penalty and those which didn't. And this was obviously at about that time, and Mr. Delano Harrison was unfamiliar with the new regime.
It's the sentencing regime for non-capital murders
Yes,
that he's not familiar with, isn't it?
Yes, and he said it's the first one he's done.
Yeah.
And then he says that, well, Judge, there's obviously no need for the allocutus to be given if there's no question of the death sentence, because the allocutus, I think, says in terms, do you have anything to say before sentence of death is passed? And but that, obviously, it wasn't necessary. And then there's a subheading, plea and mitigation. Mr. Harrison, I think with respect to him, perhaps didn't give the judge all the assistance that the judge was hoping for. He said, the sentence is, I have always thought, the most difficult judicial task. And this kind of case is one that makes me wonder whether a usual plea serves the usual purpose. I'm not clear, my lord. In this particular case, carries with it more than the usual, because it is plain, my lord, this accused, and we have no evidence before you, but you may accept it from the bar, because when I first interviewed Mr. Brown, I had occasion, my lord, to report to Mr. Justice Carl Harrison a certain difficulty I had, which in turn led to, at my request, a third examination of Mr. Brown. Doctors Otte and Leverage had occasion to interview him again, because he had a long period of 2 years or more at what the doctor describes as being at the Governor-General's pleasure.
Now, this is all quite important, isn't it? Because this is before the judge quotes from the report.
Yes.
So we know, don't we, that Dr. Leverage was the prison doctor and Dr. Otte was the consultant at Bellevue.
Yes.
And so we know from this that Mr. Harrison, before trial, had been aware of a question about his client's state of mind, and he had requested a third examination. So he was aware there had been previous examinations, and he was aware that his status up to that time was that he was being detained at the Governor-General's pleasure.
Well, you're right with respect, my lord, that this is very important, but I would not say that the inferences that you've just drawn are necessarily inevitable. Frankly, it's not clear that that is what Delano Harrison knew, because I'll have to take you to the reports and the matters.
But what else does this mean?
Well, can I just continue reading this passage and then come back to the documents which are being referred to? Because just to anticipate matters a little, it's extraordinary that the way in which Mr. Harrison puts it, he says, a long period of 2 years or more at what the doctor describes as being at the Governor-General's pleasure. Because neither of the reports, and we'll look at those two reports in a minute, make any reference to there having been a finding that he was unfit to plead. And it's also not clear, we haven't seen the third examination. It looks as though we haven't seen the third examination, unless that is in fact a reference to one of the other two, which is what we don't know. But I'm afraid that despite the best endeavours which we used at your lordship's invitation, we haven't, I think, really been able to finally nail down what exactly happened. But, my lords, it's very odd that if there had been, to Mr. Harrison's knowledge, a previous trial and a finding of unfitness to plead, that he would have expressed himself in this way. And why would he say, at what the doctor describes as being at the Governor-General's
What are the two previous examinations he's referring to? The June 2000 examination by Dr. Otte, which we've got in record 2 at 571, and then the August 2001 by Dr. Leverage, and so now a third is being sought and was indeed met.
Well, my lord, we'll look at them if I may. I would just at that point, can I just perhaps continue with these pages open before we do look at them to see the whole of the reference rather than interposing them. See, what Mr. Harrison is saying is that I was in difficulty in taking instructions. I raised it with Dr. Harrison and asked for a report. He, at this stage, certainly knows that Drs. Otte and Leveridge had seen him. He then, if we go back to page 261, I think it is, I really do not know how to treat with that, so ultimately I'll leave the matter to your judicial hand, trusting that you will treat with it judicially, may it please you. And that's the conclusion of what was originally intended to be the mitigation. The judge says,
I was only going to ask Mr. Guthrie, I want you to go on before we come back to the reports and do it in your own time, but what's the sentencing regime which is governing what Mr. Harrison is saying to the judge at this stage? Was it by chance a mandatory life sentence?
What it was, and we'll see in a moment, was at that time, we have copies of the relevant statute.
Yes.
The Offences Against the Person Act in its 1995 incarnation.
Sure.
And what the effect of it was that it was a mandatory life sentence, but with a discretionary minimum period.
Well, it's not it's a minimum period before parole, isn't it?
Yes, a minimum
So the
period
only
before-
thing that counsel can really address,
Yes.
is this right?
Yes.
Is the minimum period before parole.
Yes, and it seems that
that's
that was
what's
what
clearly unfamiliar
yes.
to him.
And that, yes,
Yes.
indeed. But he did, so to speak, make a reference to it.
Yes, he did.
For the record, the minimum period before parole under the statute at that time was 7 years. And we'll see a reference to that in the judge's words in a moment. Not to the 7 years, but to the minimum period.
For murder.
But when he sat down, the judge said to him, before you take your seat, perhaps you might want to tell me how I should exercise. Is there anything in mitigation? And he says, although I sat at the particular junction which I did, this was not without my knowing, my lord, that you have a discretion as to the minimum period for which parole will not be due. I know that. But, my lord, to suggest a figure, because of the type of offence, the nature of the particular offence, evidential material that supported the charge, is one which too sadly prevails in the country. That's obviously a reference to the high number of murders in Kingston.
And firearm.
Yes,
Yeah.
which would have been common knowledge to everyone. What I would suggest is that whatever figure your lordship ends up with, I will humbly request that your lordship add a notation relating to his affliction, the need for constant monitoring of his state. Yeah. Your lordship knows a judicial words of the wise is always useful. My lord, 15 years I was making bold to say. The law already speaks to a minimum figure, which we believe to be 7 years. The Lord already speaks to this minimum figure, but is there anything why this is the figure that should be considered? Because that should be more than adequate to one, punishment the prisoner, while yet two, seek the kind of healing which he obviously needs. When I spoke of that, my lord, the figure proffered, I was thinking in terms of the question of parole. I really believe, my lord, that there's a very real sense which I have pondered, and I'm being candid with the court. I've pondered, and the offence may not have been committed during the kind of period that, as I say, my lord, he sometimes does not recall what happened yesterday. He comes and goes. That is my experience with him. So that the period I speak of is one where monitoring his mental condition. And he says, Judge, that condition doesn't remain now, it's on and off. Mr. Harrison, I think, my lord, that if he adheres to the medication regime, which is a heavy one, I gather he tends to be lucid, but he has to be constantly monitored. He's been diagnosed with one of the more serious conditions. And this is why I say that a matter of sentencing is all the more difficult in this case, I would think. My lord, I don't know I can assist you further. Just how long was he in custody? In custody since the 9th of September 1998. Well, whether that's a mistranscription is not the right date. He was the 30th of September 1998. The last examination to which you referred, and this is a clue to what reports were being considered, speaks to his having an auditory history. Auditory, and there's open inverted commas, auditory hallucinations in the past but not presently. He displayed no thought disorder or evidence of delusional thinking. There was no impairment of attention, concentration, orientation, or memory.
This is a quotation from what?
Well, I'm going to take you to it in a moment.
Page 570, isn't it?
Yes, it's a quotation from Dr. Otte.
Yeah.
and he seemed to be of average intelligence. And it goes on to say, the features of schizophrenic psychotic disorder which he previously displayed are presently in remission because of treatment. It is likely, however, that this illness would have caused substantial impairment of his mental state at the time the offence was committed. That is what the report speaks to. Certainly the evidence as is, this is the judge, did not suggest that at the time the offence was committed, he was suffering from this mental disorder the way the offence was committed. Well, we think there's reason to criticise that kind of assumption. And then Mr. Harrison says, if I had that kind of information, then there might have been a different approach to the conduct of the defence, the question of the level of responsibility. And his lordship says, but I can recall a motive was suggested, which seems to have been, he had a motive for doing what he did, but I will take that into account in passing sentence. Again, we would respectfully suggest that that wasn't the best approach to the position. In relation to what Mr. Harrison says, it is obviously difficult at this distance to infer exactly what he meant, but the fact is that if Mr. Harrison had had the sort of information which became available to him later, it is very likely that the underlying proceedings would have happened in a different way. And I will, obviously that is something which I will want to develop. In the sentencing remarks, the judge seems to refer to the motive towards the foot of page 264. You can't just snuff out a person's life because they diss you, as the evidence discloses. That seems to be what the judge was thinking about in terms of a motive. But we would respectfully say, or this is hardly inconsistent or necessarily inconsistent if it's indeed true, that with mental disturbance at the time of commission of the offence.
Mr. Governor, just going back a moment, are you inviting us to read line 5 at 264, if I'd had that kind of information, as meaning if I'd had Dr. Otter's report?
Well, I'm not sure I can necessarily say it necessarily means that. I don't think I can, but I don't think it necessarily means it's possible to say what it does necessarily mean.
If, which I think other evidence suggests, he had Dr. Otter's report, which he had indeed asked the judge to direct, then, and that he had made reference to the report, and the judge says, well, yes, well, the report to which you're referring says such and such. When he says, if I had that kind of information, things might have been different, is that not understandable as, well, indeed, if I'd had information indicative that the type of, that his behaviour was suggestive that it was done under a disorder, then it would have been different, because the judge has made the point, well, there's nothing in the way in which the offence was carried out, which is, or his associated behaviour suggestive of mental abnormality, to which Harrison says, well, if I'd had that sort of information, we'd have looked at it differently. Isn't that the,
well, I don't think that's the natural reading of it, no.
Right.
I think it may be a possible reading of it, but I certainly wouldn't suggest that.
So you say it should be read, do you say it should be read as meaning, good gracious, I've not seen that report?
Well, it's certainly possible to read it on the basis that if he had realised the extent of the disability, then the conduct of the defence would have been different.
Well, that can only mean if I'd seen the report.
Well,
I mean, it's got to mean one, got to mean one or the other, hasn't it, Mr. Guthrie? It's
well,
either, good heavens, I've never seen that report, which we shall see in a minute at 570.
Yeah.
Or it's, well, Dr. Otte raised the question, but there simply wasn't any evidence on which I could advance.
Well,
it diminished. It means one or other of those.
Well, I understand what you're saying, but what one's not. the area of doubt, if you like, is what should be, is the limited amount of the information that he would have got even from Dr. Otti's report.
Well, that's the point.
Yes.
And that may be what he's saying.
I mean, he's saying that all I've got from, I mean, he may have been saying, well, I agree with your lordship that I didn't have any direct information that the nature of the offence was indicated by his mental disorder.
Well, I didn't have. I had that one sentence in the report,
Yes.
but of course that isn't enough for diminish. I mean, if you spell it all out, that's not enough for diminish. What you've got to have is material to suggest that at the time his responsibility, what he did in shooting someone, was substantially impaired. It may mean that, or it might mean, as far as I can see, or could mean, simply reading the page, well, I've never seen that report, and therefore I didn't have that hint in it.
But there's also the question of when he saw the report. Whether he saw it before the trial,
Well, yes,
between
certainly.
the trial and sentencing. There's also a
Yes.
halfway house, my lord. It shouldn't, I mean, I will be coming to this in a little more detail, obviously, but it is not a straightforward situation of whether or not if I had seen that, I would have raised the defence of diminished responsibility. It's a further point that if he had known that there was a bigger question mark over the defendant's mental health than he thought there was, he would have run the case in a different way. And
Viz what though?
And, for example, we'll see that the way in which the trial developed, there was a lot of comment about things not being put, etc., which he would have been able to protest about if he'd known that his client was in a difficult... Well, that's just one example. But I want to come to that in a little more detail. Perhaps I should take up at this stage, there's only a little bit more of the relevant passage at the end of the trial. As I say, the judge refers again at the top of 265. As I said before, the way this offence was committed did not suggest you were labouring under any mental disorder.
He also says you have 3 previous convictions.
It's almost as if he made his note. His sentencing remarks before he got the information and didn't strike it out.
One thing which one can say from all this is that the judge appears to have been at no stage aware that there had been a previous finding by a jury that he was unfit to plead, because there's no reference to that other than in Mrs. Fraser's remarks. But he appears to have
But in what other in what other circumstances would you be detained at the governor's pleasure?
Well, that's what. But that, of course, was prefaced by this rather odd way, as the doctors describe it. But one doesn't need to look at what happened in a bit more detail at the earlier stages as well as now. But, my lords, can I ask you to look at, really take up the invitation of looking at these documents which are referred to in the thing. The first, it's the references at the bottom of page 260. I had occasion to report to Mr. Justice Carl Harrison. Now, he refers to Dr. Otti and Leverage having occasion to interview him again because he had a long period of 2 years or more. Dr. Otti's report there is at page 570.
That's his 2002 report.
Yes.
And the first of the 3 reports had been his 2000 report.
Well, no, I don't think so, my lord, because I don't think that is the 3rd report.
Well, there had been an examination by Dr. Otti, and quite an important one, in June 2000, hadn't there?
Well, there had been, but can we just deal with this particular report first?
You want to do the last one first?
Well, I think so, because I think the first one, there's no indication that the first one was seen by anyone at this trial.
Well, you must do it in your own time, but it is the fact, isn't it, that there are 3 documents.
Well, there's also reference to a 3rd document elsewhere internally, which is obviously not either of these. But can we just look, first of all, at the November the 20th, 2002 report, which is the Dr. Otti report, which is read from by the judge in his sentencing remarks. And you'll see that is November the 20th. That's the one which...
so this is 570.
This is 570.
Yep.
And this, I would say, we can be reasonably confident is the report referred to in the third line from the bottom of page 260.
Quite.
Yes.
Occasion, because it's again referred to by
Yep.
the judge, and it appears to be the report in which the exchange we've just been considering is talked about in the context of, if I had that kind of information, then there might have been a different approach to the conduct of the defence.
Yeah, longish paragraph, three up from the bottom.
Yes.
Mental status examination begins. There's the history of the auditory hallucinations.
Yes,
From
not presently.
the bit that the judge was quoting.
Yes, and,
Yep.
and the vital last paragraph,
Yep.
last sentence, it's likely the illness would have caused substantial impairment of his mental state.
We just need to note, don't we, where the examination took place, the opening paragraph. It was the examination at Belleville.
Yes.
Yeah.
Now, the second report, my lord, Dr. Leverage, appears to be there at page 573.
Yeah, now that's a year earlier.
That's a year earlier, and that is stamped Registrar's Chambers, 14th of August 2001, Supreme Court. Psychiatric report on Richard Brown. I saw Richard Brown for the first time in November 2000. He was psychotic, totally irrational. Since that time, he's made significant progress. Well, just to go to the foot of the report, a young man, very cooperative. His display of emotion seemed normal. He exhibited no evidence of active psychopathology. It's my opinion Mr. Richard Brown is suffering from a schizophrenic disorder. His symptoms are now resolved and he needs to be on medication. I believe that he is now competent to stand trial. Now, before leaving those two reports, which I suggest are most likely those referred to at that stage of the trial, neither of them made any reference to a finding that he had been unfit.
I really don't think we can make sense of the sequence of reports and what Mr. Harrison was referring to without actually looking at the antecedent Dr. Otti report.
Well, that isn't, what I say is that is not the third report.
No, it's the first of three.
No, but it's not one of the three.
Well,
Because the reason I say that, my lord, is because the context in which he's talking, I had in turn led to, at my request, a third examination of Mr. Brown. Now, that is neither of the reports that you've seen, because it's referred to separately, and also internally.
Duffy, why do you say that?
Because internally, there's a...
You may be right, but I'm not following. Why can't 570 be the third report sought by Mr. Harrison and prepared by Dr. Otti for him?
Well, he doesn't say so, and indeed, we'll see from the DPP writes about this, but also we have a reference at page 554 in the bundle,
Quite.
which makes it clear that apparently in November 2002, Mr. Leverage is asked for a further report.
Well, I know, but can we look at that, please? 554, because it may help. 554 is, on the face of it, something from not the hospital records, but the prison medical records.
Yes.
Is that right?
Yes, but it appears to be signed GL.
Precisely.
Leverage, Dr.
Yes.
Leverage.
Quite.
Yes.
He's the prison doctor, not the consultant.
Yes.
We know he's the prison doctor
He's
because...
a psychiatrist.
Yes, we know he's the prison doctor because Dr. Otti says so on page 570 in his second paragraph.
Yes.
You see? Right. Now, wait a minute. If that's right, then go back to 554. November 2002, Dr. Leverage, the prison psychiatrist, is recording, is he, that a report for counsel, for attorney at law Delano Harrison, has been prepared.
Yes. But we don't know. I would have read that was a separate report.
Well, I know
we
you
haven't seen.
But what I'm asking you to consider is the real possibility that given that the date for that appears to be a two-figure date in November 2002, look at 554,
Well, I think my learned friend thinks it's the 26th.
does, well,
That's what he says.
well, he may, but you can't, speaking for myself, it's impossible to decipher what the day is. But it is November 2002, isn't it?
Yes.
Right, and lo and behold, on 570, there is a report from Dr. Otte, dated the 20th of November 2002, consequent on an examination at the hospital on the 19th.
So he's taken from the prison to the hospital for the examination by Dr. Otte, as Mr. Harrison had asked the judge to do, to direct.
Well, with respect, that's making a number of assumptions. It may be right.
Well, it's what Mr. Harrison told the judge as well.
Well, he said that...
Page 260.
Well, I would have said that it's not clear that that is what he was telling the judge.
He says, I had occasion to report to Mr. Justice Carl Harrison a difficulty I had, which led to, at my request, a third examination of Mr. Brown. Doctors Otte and Leverage had occasion to interview him again. That's what he told the judge, and that's entirely consistent with Dr. Leverage, the prison doctor, attending with the prisoner at Bellevue, where Dr. Otte carries out the report.
But it's not consistent with Dr. Leverage interviewing him again, because Dr. Leverage had not, as far as, unless there's a third report which we haven't seen.
That's the trouble, isn't it, Mr. Guy? But if you're right, and clearly it isn't completely transparent, but if you're right, does it follow that there must somewhere, that Dr. Leverage must have written a report for Mr. Harrison, which has disappeared?
Well, that is what we think.
And moreover, presumably, are you asking us to infer that that Mr. Harrison never had it?
Well, we don't know.
But he's asked for it.
Yes.
If he hadn't had it,
Yes.
he might be expected to say, where is it?
I can't give your lordships a definite answer to what happened, and with respect, it's very difficult to expect Mr. Brown to do so.
Can I invite your comment on this possibility, which might be thought to be consistent both with the documents and with what Mr. Harrison told the judge? Would you indulge me if we just look for a moment at the 2000 report by Dr. Otte at page 571?
Quite.
Just a moment, sorry. Yes, I've got that.
Now, this is the consultant in 2000 saying that, reporting that the patient, paragraph 4, is unable to give a coherent account of the offence, gives incoherent responses, muttering, seemingly responded to hallucinatory voices, gross thought disorder, unfit to plead. That's in 2000. In 2001, the prison doctor, Dr. Leverage, takes the view he is now fit. And you've taken us to that report. Yeah. Mr. Harrison is troubled, as he told the judge, because his client seemed to be in a fluctuating condition. Yeah. So he's in the situation that in 2000, Dr. Otte, the consultant, has said unfit to plead. In 2001, the prison doctor has said fit to plead. Yeah. Mr. Harrison is concerned about the state of the patient client's health, so he asked the doctor for a third examination. Leverage goes along to the hospital, notes up in the notes that this is a report for attorney at law who had requested the examination, and we get the third report, which is by Dr. Otte. Now that as a scenario, seems to me to make complete sense of what Mr. Harrison was telling the judge. What's wrong with it?
Well, we simply can't be certain that you're right. What it doesn't explain is, if you like, the glossing over of the conclusion of Dr. Otti's report. It is likely that the illness would have caused substantial impairment of his mental state at the time that the offence was allegedly committed, which is what Harrison says, if I had had that kind of information.
But if you're right on that, because we know two fixed facts. We know that Mr. Harrison had asked the judge to direct an up-to-date examination because he was worried about the client's health.
Yes.
And we know that Dr. Leverage thought that this report was being prepared for Mr. Harrison, because he said so in the notes.
But which report, with respect?
The report which was being produced in November 2002.
Yes, but you said this report.
Yes, the third report.
Well, but we don't know that this report was Dr. Otti's report.
Well, we know that A, Mr. Harrison had asked the judge for the report, and B, that Dr. Leverage was referring to a report being prepared for Mr. Harrison.
Yeah.
Now, it is, of course, possible that although Mr. Harrison had asked the report, although the doctor thought the report was being prepared for Mr. Harrison, he never went to Mr. Harrison, and Mr. Harrison never asked for it again and never chased it up. But have we got any evidence, any statement from Mr. Harrison or anything to suggest that that's actually what happened?
Well,
and that Mr. Harrison just
I'm
didn't
going
bother
to
to
come
follow
to
it
what
up?
we've got from Mr. Harrison in a moment, but the fact is that the inference I would have drawn from 554 was that Mr. Leverage was saying, I am going to write a further report, because he signs report to be prepared for counsel GL. I think it's rather a stretch to suggest that in making that annotation, he's referring to a report to be made in the future by Dr. Otti. And of course, if my learned friend might be right as to the date being the 26th of November, it can't be that report, because the request by Mr. Harrison is made or recorded after the date of Dr. Otti's report.
Well, hang on. No, forgive me.
It's
Forgive
the
me.
20th of November
Forgive me.
2002.
You've inadvertently read 554 as reading report to be prepared.
Yes.
Actually, not what it says.
Well, if it referred to I would have respectfully thought that it was unlikely to have referred to a report which had been.
Why?
Well,
What is the last sentence?
Why ever not? The note might have been made at any time. It may have been made on the 20th, or it may have been made a couple of days later. But it's a note that there is a report for counsel, isn't it?
well,
What is the last sentence?
Why
What's
would-
the last line say? The word on the second line say?
Prepared.
prepared.
Yeah.
It
Report.
says report for attorney at law. I would have thought the natural reading of that was that it was contemporaneous with the preparation of the report.
Well, it could be. I agree, but it doesn't necessarily follow, does it?
Well, I'm very anxious that one shouldn't be, so to speak, making inferences which might be contrary to my client's interest in this appeal.
Well, I follow that,
This
but
is
we
a
do
pure
have
speculation.
what is not an inference is Mr. Harrison's statement to the judge at 260 that at my request, a third examination, not a third report, a third examination of Mr. Brown, Doctors Otti and Leverage had occasion to interview him again. So that was his understanding, that there had been a third examination conducted by Otti and Leverage at his request.
Yeah. Well, that
And I can't see what the third examination is if it's not the third in the context of the 2000 examination by Otti and the 2001 examination by Leverage.
Well, surely it's the inference from that passage is that the Leverage report had occasion to interview him again is a different report or a different examination to the one which had been done in the year 2001, because he uses the word again.
Different to 573, you say?
Yes.
Well, yes, absolutely.
That's the difference, is that there's another leverage report which we don't have.
Well, there is, all right, that's what you say, yes.
But I think my broader point is, it's all very well trying to tease out of this very rather Delphic exchange between everybody a sequence of events which is somehow going to be used to suggest that Mr. Harrison knew all along of the exact position.
So what do you say we are to read out of these documents? What do you say we are to read out of these documents?
Well, I would respectfully submit that, as your Lordship said, one thing we definitely know is that he said that he'd asked for an examination. One thing we also definitely know, he said, is that if he'd had that kind of information then, there may have been a different approach to the conduct of the defence.
So he
must have meant something
asked for
like
it but didn't get it, basically.
Yeah.
Yeah.
Mr. Guthrie, could you help me about the possible role of Mr. Justice Carl Harrison? Now, when there has been a jury verdict that somebody is unfit to plead, and when the prosecution consider that that has changed and he should now have a trial, does the prosecution go on notice before a judge? And might this have been Mr. Justice Carl Harrison?
What I'm going to come to what happened at that stage. We do have a letter from the DPP about it, but before I come to that particular letter, may I just, having shown you this passage, which I respectfully submit is not something you can be confident about, at the very least, just tell your Lordships that we have done our very best to try and find out from Mr. Harrison what the position was. And I think it's important that you should know that we have done that. There is detail of it in the bundles. Mr. Wright, who sits behind me and went to Jamaica in this case.
He's done an astonishingly detailed investigation. All pro bono, as we understand.
Absolutely. And at page 338
Of?
bundle 2 it is. Oh, yes, volume 2 of the record. It's
Yeah.
You'll see at page 338, paragraph 41 of Mr. Wright's first affidavit, that he telephoned Mr. Harrison QC, and he initially had a conversation with him, and at paragraph 42, Mr. Harrison said he'd refreshed his memory by reading the Appellant's Court of Appeal judgment, said the case was a serious injustice and that he was flabbergasted by that.
That's a reference to the use of both the
Yes.
deposition and the witness statement
Yes.
of the dead witness.
Yes.
Yeah.
And then Mr. Wright asked him if he remembered anything about the appellant's mental illness. And Mr. Harrison said he did not recollect anything. He'd refreshed his memory of the case, which only dealt with the evidential issues regarding Mr. White. Then Mr. Wright read to him the extract from the trial transcript, which I've just read to you. Paragraph 45, Mr. Harrison demonstrated surprise at this passage and said he could not remember such an exchange with the judge. I asked Mr. Harrison if he remembered anything about the appellant's mental illness, and he said no. He had no recollection of it being an issue. I asked him if he'd seen any medical reports in relation to the appellant by Dr. Leveridge or Dr. Ito, or spoken to either of them. He said he could not remember. I asked him why the appellant's medical condition and level of responsibility was not raised at the Court of Appeal. He said he could not remember. I asked for a copy of his file, and he said he wouldn't have it, having moved office. He would happy to assist with the case if he could. But unfortunately, subsequent attempts, which are fully set out in Mr. Wright's second affidavit at page 460, didn't get any further forward. I won't read out the whole of the paragraphs. It's 7 to 10 of the second affidavit. But it does seem that there were any number of telephone calls, emails, attempts to chase up, but unfortunately there was nothing forthcoming. I might say at the same time that we haven't either heard any account from Mrs. Fraser, who represented the Crown at the trial as to what was understood at the time. And we are left in what, in my view, is an unsatisfactory position, which I would respectfully suggest can't be filled by attempting to prefer one version of possible events to another version of possible events. But we do have a letter from the DPP, which I don't know if it's got as far as your lordship's possession at the moment. It was received last Thursday, although it's dated November the 18th, 2015. When I say it was received, I'm not making any complaint, because I know my letter friends received it on the last Thursday.
Is it 18th of November?
Yes, it is, and it's from
We've got it-
Paula Llewellyn, who is the...
We've got it at the front of a little bundle of additional documents with 3 tabs.
I don't think, with respect, that this necessarily solves the factual position. She makes a number of comments onto the law, which I'll be coming back to. But at the foot of the page, it says, when the appellant's antecedents were discussed at trial, so that must be in the passages to which I've shown you, he was remanded at the Governor-General's pleasure on the 31st of October as he was unfit to plead.
Yeah.
And then she refers to paragraphs we've seen. Even though the words were used, unfit to plead, pursuant to strictly determined, it was a finding of insanity and detention in custody until the pleasure of the Governor-General be known. Then she refers to the law in 2006, which I'll come back to. Then in the second paragraph, she says, before 2006, when a defendant was found unfit to plead and ordered to be kept in custody at the pleasure of the Governor-General, he would receive the necessary medication to treat his condition. In addition, he would be continually evaluated, and if there's no improvement, a report from the attending psychiatrist is sent to the court. The defendant is placed again before the court so that the matter can be dealt with. There is no other trial of the defendant's fitness as the psychiatric report is deemed sufficient. Now, that may or may not be the report, the first report of Dr. Leverett, which is stamped received by the registry, or another report.
Well, yes, it's entirely consistent with it being page 573, isn't it?
Yes, it is, yes.
Dr. Leverage is the prison doctor. His report is stamped as received by the court a few days after it was written.
Yes.
And it reports on the chap's current
But unfortunately,
fitness for
it's
trial.
not entirely clear what is meant by the sentence, the defendant is placed again before the court so the matter can be dealt with. And which matter is that? Is that the trial or is that the issue of fitness to plead?
She must mean the trial because of the next sentence. Look at the next
She
sentence.
says there is no other trial of the defendant's fitness to plead
Right.
as the psychiatric report is deemed sufficient. And is that deemed sufficient at a hearing before the court or what? I mean, that's what I'm concerned about is what in fact happens in order to, so to speak, permit the defendant to be tried. She says in the next sentence, the psychiatric report usually includes specific points which are necessary for the defendant to be able to follow and assist in his defense. A possible outcome is an acquittal after trial or at least a grant of bail where considered appropriate. Now, certainly the reports we've seen don't have any material which dealing with what is used in that paragraph. When the defendant is remanded in custody at the Governor-General's pleasure, this is tantamount to a sentence of sorts, though with a view to accommodating controlled treatment in a suitable psychiatric ward. It is therefore justified that a more rigorous procedure should be required, that is, a finding of the jury of unfit to plead before a defendant is so committed, and this can be for a very long time. As it relates to the specific case of the appellant, after he was declared unfit to stand trial, he was detained. While being detained, he would have received medication for his condition under the guidance of a psychiatrist. On the 9th of August 2001, a psychiatric report declared the appellant fit to plead. That's 573. And it was on that basis he was brought back to court. Prior to the commencement of the trial, another psychiatric report was supplied to the court, which provided an even more current indication that the appellant was fit to plead. Now, that would appear to be Dr. Otti.
Yeah.
But it doesn't fit in with the the proposition that Dr. Otti was actually reporting to Mr. Harrison. So again, I'm afraid it doesn't.
You're certainly able to say that by the time of the sentencing exercise, the judge had in front of him Dr. Otti's report.
Well, no, exactly
570.
not. Exactly not so, my lord.
Not.
No, absolutely not. Because one thing that I would submit is crystal clear from everything that happened after the verdict is that the judge was taken completely by surprise when he heard that there had been a previous trial.
Well, hang on a minute. He read from it, didn't he, on page
Yes,
263?
that was not. That was after the trial was concluded.
That's what I said at the
Yes.
sentencing stage.
At the sentencing stage. I'm sorry.
And after an
I'm sorry.
adjournment.
We're at cross purposes.
Yes.
And after an adjournment. What is crystal clear is that until Mr. Ferren stood up to read the defendant's antecedents, Mr. Justice Pitter, whatever Mr. Justice Cole Harrison might have known, didn't know.
No, I thought it was...
And it seems to me, with respect, that that's a very strong indicator that something may have gone wrong with the process of justice in this particular case.
Well,
because the trial judge did not know, and it's quite plain that he did not know, that there had been a serious issue as to the insanity and fitness to plead of the defendant who he was about to try with a jury. And we submit that that of itself is a reason why the trial should be seen as having been unsatisfactory and very likely, and you certainly cannot rule out the risk that a miscarriage of justice took place. Lord, I wanted to take you not to very much of the medical information.
But if the trial judge had known, what was he to do?
Well, that is, if you like, a very difficult question to answer. But he would certainly have been likely to approach, and if Mr. Harrison had known, he would have been likely to approach the way in which the trial was conducted.
Well, there are two different questions, aren't there, Mr. Guthrie? The first question is whether counsel was aware of it,
Yes.
and what he knew. But the question you were asked was a different one, which is, supposing the judge has got Dr. Otti's report on the court file, that is to say, page 570, rather than 571, or rather as well as 571, probably. The question you were asked is, what's the judge to do about it?
Well, the judge, at the very least, would have raised the issue.
Which issue?
Have you been raised the issue?
With counsel. So are you
with
aware?
counsel, yes,
With counsel. With counsel. What I think the authorities are quite clear, and I'm not going to be suggesting anything contrary, is it was not for the judge suddenly to row in and say you ought to be running diminished responsibility or anything like that. But that is really, I don't need to go so far as that in any event.
No, Mr. Harrison, have you seen Dr. Otti's report?
Yes.
Is there any medical issue?
Yes,
Yes?
and I would have thought any judge would have regarded that as an essential precaution,
Right.
and might well have gone rather further than that. But the fact is, it's quite obvious that that Mr. Harrison did not know that there had been a previous trial of any sort.
I'm afraid you've yet to convince me of that.
Well, I rely on what he said when the matter arose.
It's it's 264, is it?
Well, it's,
if I had
actually,
that
no,
card.
it starts before then.
Yeah, all right. Well, we've got it.
It's really the whole of the passage, looking at from the very beginning.
Yep.
260, is it?
Yes. Well, in fact, my lord, it's is it not the first matter is 250. My lord, I didn't know about any of those. And of course, the third one was the alleged conviction. But he said, I didn't know any of those. I'm particularly interested in the last one.
Yeah.
It carries certain implications. I'd got the impression the accused was in custody for several years by virtue of his illness. But what he doesn't say is, my understanding was that he'd previously been found unfit to plead. And one can't say, well, of course he must have done, because in this case, it's
What
quite
did he know
apparent the
about
judge
it?
didn't.
I mean, the trouble is, we don't know what he knew about the illness. We don't know whether he asked his client what his illness was, or whether it was a mental illness, or what it was. We just don't know about that.
Well, we do know that he told the court that he had no knowledge of what had happened in, and he did expand on that a bit, my lords, because when he comes back into court on page 253, he says, you'll recall Mr. Brown says that he doesn't recall, and your lordship may by now have some idea of this toing and froing mentally. My lord, sir, his family, mother and father and sisters are adamant that they know of no such trial or conviction, and their manner is such in the denial that I take their word for it.
Well, he hadn't been convicted, but
No, but he hadn't been tried, but he had been tried.
Well, yes, I dare say, but come on, your counsel goes to the mother and the father and says, look, they're saying he's been convicted of murder, has he? Good heavens, no.
Well, again, that may have been how the conversation was gone. He may have said, did anything previously happen on the 30th of October 2000? And it's perhaps a convenient moment. I was going to come to this a little bit later.
just before you do that, because things are getting a little bit tangled from time to time, can I just get clear which of two things you're saying? It may be both. Proposition 1, there was a live issue as to his fitness to stand trial, which was not properly explored.
Yeah.
Proposition 2, there was a viable defence of diminished responsibility, which was not properly explored. Now, there are different things, but you might be saying both.
Well, I don't
Which
think I
are you
have to go
saying?
quite so far as either.
Right.
Because I think I can say there was not necessarily a live issue as to his mental instability, or I would say that, but the better way of putting it perhaps is there was an unresolved issue as to his fitness to plead.
What, as at 2003?
Yes.
Oh, I see.
Because there was still a verdict of a jury that he was unfit to plead.
I'm sorry. Do you mean legally unresolved or
Yes,
medically
legally
unresolved?
unresolved. It's not clear whether it was medically unresolved or not.
Well, no, but are you asking us to infer that if things had gone differently, he and the issue of his fitness to plead had been investigated again in January 2003, there is a real possibility that he would have been found unfit to plead then?
Well, what there might have been was a conclusion that he was, that might have been the result, but there might also have been a further investigation of his mental state, which would have cast a new light on what had happened in 1998. But there's also, if I could answer my Lord Toulson's second question, I was saying that there was offensive available, diminished responsibility available. The short answer to that is there may have been. I can't say there definitely was or there definitely was not.
That's rather an unsatisfactory state of affairs for us to have now, because one sometimes gets an appeal to the board where there is placed before the board a properly prepared psychiatric report saying, here is the medical foundation for saying that there was a DR issue fit to go to the jury. My client's been deprived of that. Look at this as fresh evidence and set aside the trial, set aside the verdict. But you're not in a position to do that. We don't have, as it seems to me, either any psychiatric report to that effect.
No, we have an up-to-date report saying that he's all right now, subject to taking his medicine.
Yeah.
But what we have is the contemporaneous report with the trial of Dr. Otti that says that his he may have been substantially impaired.
But do you say that, I mean, if a matter had rested there, I can see you saying you might want to ask Dr. Otti some further questions.
Yes.
But are you saying that if that had been put before a court as it was,
Well, not as it was, no, but what it might have done would have been triggered
Prompt a line
a
of
proper
inquiry.
inquiry, a line of
and
inquiry.
that's a line of inquiry which has never been pursued up to and including 2015, isn't it?
Well, that is right. But I mean, it's very difficult with respect, I think, to criticise my client
No,
for that,
just
for that
inquiring as to
because this matter only came to anybody's attention here in 2013, and one can imagine the objections which would be made to trying to rewrite the situation then.
But you're asking the board to advise that the conviction be quashed on the basis that it is possible that proper inquiries might have led to a defence, although you can't say that it would.
That is one strand of a much broader argument than that.
But if we go back to not the fitness to plead point, it's very difficult to see where the evidence is that he was not fit to plead at the material time when it was decided that he was fit to plead. I mean, these doctors both
say
say
that it was decided that he was fit to plead.
Sorry?
I don't think a decision was made that he was fit to plead other than by the psychiatrist.
Well, that's precisely how it would happen, of course, in England, isn't it?
Yes, subject to the court being made aware of the position. And
the other thing that we know is that in due course he gave evidence, both in chief and under cross-examination, about precisely what had happened at the time. Now, it's virtually impossible for that to happen in the case of someone who is unfit to plead, isn't it?
Well,
unfit to plead means unable to participate in the trial, unable to understand what's going on, unable to give instructions. Pritchard.
yes.
Well, do you say that there is any possibility that Mr. Brown was unfit to plead in 2003?
Well, there's a possibility that he...
You do? All right.
I mean,
But that's based upon what, though? The fact that he'd been held to be unfit to plead previously?
Yes.
That's the only point.
Yeah. Well, if he was
I can see you have a point or a possible point in relation to the penultimate sentence on page 570, which is the Dr. Otti's opinion as to what the position was at the time of the trial. I can understand that, the original
Time of the offence.
Well,
the offence. I'm sorry, the offence.
Yes, and that point...
And I can see there may be some force in that, but it's very difficult to see how you get the fitness to plead point.
Well, I think I do accept that, but as I say, it doesn't diminish the point as to what was the position back in 1998.
True. Perhaps we'd better get on to that. I'm a little bit bothered about the time because you don't have a lot longer.
Well,
you have been subjected to a certain amount of assault verbally, but you're entirely capable of dealing with that.
Well, it's your word, not mine.
Speaking for myself, I deny assault.
No, I wasn't referring to my Lord Clerk.
Well, I do have a little bit more ground to cover, so perhaps I should try and cover it. I've got a number of references in the record which I think I should take you to, which are relevant to the, if you like, the overall, can you be satisfied at the end of this day that there wasn't a miscarriage of justice? It's, first of all, there's obviously no dispute that the appellant has a long history of mental disorder, so I can avoid taking you to each and every indication. Can I just remind you, though, that the date of the murder was the 22nd of September 1998, and at that time, in the fairly recent past, he had been reported as suffering from auditory hallucinations, and he was plainly in a very bad way back in September 1997. Well, the reference in the record is at volume 2, page 373.
So it's 97 he was in a bad way.
Well, he was probably in a bad way for some considerable time before that, but I wasn't going to go back to 87, which is when he apparently started being in need of mental treatment. But in
The
September,
last one you want is actually November 97 rather than September, isn't it? 374?
373 was what I was going to ask you to look at.
Okay.
Yes, well, the November 90, I'm sorry, the 374, I don't think there is a November 97 entry. Is it? Is that November?
Your chronology says it is.
Yeah, there is. I'm not sure if that's 97 or 92.
I don't think it can be 92. I thought it was 92 at first.
Well, that's my fault for misreading it myself.
I
I'm
thought
sorry.
it was 92 at first, and then one compares the writing of the one on the previous page.
Thank you.
They very much appear to have been written by the same person.
And the chronology, which you have helped, I mean, it's a super chronology, thank you very much, whoever prepared it, but the chronology has that entry at page 346 of the bundle down as the 18th of November 97.
Yes, well, I should have read my own chronology.
And
But I was particularly looking at 373, which is September 97, because that refers to the points are, I don't think weakened in any way by these individual documents. The fact is he's in a bad way before, and not very long before, the murder takes place. When it does take place, his first appearance at the gun court on the page 376 is the reference to it.
yeah.
The letter's written October the 13th, 98. He'd been in front of the resident magistrate, I think it is, on the 12th, and he was acting extremely strangely, sufficiently strangely for the judge to have referred him for psychiatric evaluation, which is, as one knows, not a particularly usual thing to happen. And although there's a reference to his being taken to the Bellevue Hospital, which is the Kingston Mental Hospital, on the 21st of October, it suggested that he might be malingering. That's at page 374.
Yeah.
The fact is that the symptoms that he was being reported appear to be entirely consistent with what the doctors accepted both before and after, and I suggest there's really nothing to be gained from the fact that his business of being confused, etc., is all of a piece with the general diagnosis, both long before and after the offence. And he's back in front of the court on the 11th of January 1999, and one sees the reference to that at page 378. An order was made that he be taken to get a psychiatric evaluation, so again the judge is sufficiently concerned for that to happen. We look at page 379. He is referred for immediate examination at 380. There's a reference to the fact that he'd been before the gun court on the 30th of March, and again there's a problem. Then the page at 381, well, I'm sorry, it's very difficult to read there. It's actually also at page 579. You'll see that at that stage. Sorry, I should have just, I think, perhaps taken you back to 370 as well. That is the.
Did you say it was also at 575?
Sorry, 579 is a copy.
579.
579
Forgive me.
is a much better.
It's a much better copy of the earlier one.
Thank you.
I'm sorry, I think I didn't take you to 370, which is an important entry, because it's the one referred to. He's taken to the emergency room in January 1999 with a referral from the gun court, psychiatric evaluation, escorted by the police on examination, handcuffed, mental state, I think quiet and cooperative, however, does not seem to understand the charge, speech not clear, admits.
Sorry, what page is that?
Page 370.
370.
Speech not clear, admits to hearing voices saying to him, beware of dark shadows who eat people. And he's referred to the forensic psychiatrist. And I think, just to go, I meant that's going back a little in time. One sees that.
This was the nurse's notes, wasn't it, of what happened? If you look on page
All I could
369.
say with some confidence is that at about this time, in 1999, he's plainly very seriously mentally unwell indeed. And I think it is important to look at this particular time, because the next stage in the legal proceedings was the preliminary inquiry, which took place in 1999. And they assumed a considerable importance in this case because of the fact that one of the, or in fact the only witness who the prosecution relied on died before the trial. The only person who gave evidence as to the circumstances. The witness was called Arthurham White. The preliminary inquiry took place in 1999, and Mr. Arthurham White gave evidence on the 17th of June 1999. I think your lordships know that Mr. White was, his evidence was the basis of the appeal to the Court of Appeal in Jamaica. And it had been admitted, although he was dead, under the provisions of Section 34 of the Justices of the Peace Jurisdiction Act. And that is at divider 25. Of the authorities bundle. We may have to provide you with the title page. If I can just tell your lordships, it's the Justice of the Peace Jurisdiction Act.
What's the relevance of this to your present argument?
Well, I'm taking you through the sequence of events by reference to two things, really. What happened in court and what was the state of the appellant's mental condition at the relevant times.
At the trial,
And
at when? At
the committal proceedings.
yes, but do these points go to his mental condition at the time of the offence?
Well, they go to whether the trial was fair, and whether you can be satisfied that that his mental condition didn't have such an effect on the trial as.
Is this a separate point? Is the point that you're working towards that there ought not to have been admitted the evidence of White at the trial, because at the time of the preliminary inquiry, he was not in a proper state to be able to instruct counsel to put the cross-examination?
Yes, that is the separate point.
Because that, I mean, the admissibility of White's evidence at the trial prior to admitting it was explored in the Court of Appeal. And I didn't understand that to be part of your appeal to the board.
I had understood that it was part.
Yes.
As I understood it, you've got three separate complaints. One is the fitness to plead one, which we have explored very thoroughly. The other is the judge should have asked about diminished responsibility.
Well, not just diminished responsibility, but.
But the third is, in any event, his mental state, particularly at the time of the when he was being interviewed and when the committal proceedings took place at which Mr. White was examined and cross-examined, is extremely relevant to whether those things should have been admitted or the way in which they should have been admitted. That was I thought that was a completely separate third point in your
I was extremely grateful, my lady.
I'm behind the curve. Well, is it also, therefore, part of the case that his statement under caution and his oral admissions, none of that should have gone in because there was a query as to his mental state at the time when he allegedly made those remarks?
Yes.
So in fact, so really what you're saying is that the evidence of the independent witness shouldn't have gone in and the evidence of the defendant shouldn't have gone in. And obviously, since they were the two limbs of the prosecution's case, the whole proceeding was unfair.
Well, you put these matters to me very directly. I'm trying with respect to be fairly modest in the way in which I put it, because I don't think I can say it's a black and white situation. What I'm saying is that the information about this man's mental state creates a considerable doubt as to whether the trial proceeded in a satisfactory and fair manner. And there are various aspects to that. And one aspect, which I'm on at the moment, is whether or not Arthurum's White's evidence should have been admitted.
But forgive me, I mean, admissibility is, at the end of the day, a black or white issue.
Yeah.
And I just want to get clear, I understand it to be your case that because of question marks over his mental health, the evidence of his, the appellant's remarks to the police was not admissible. Yeah. Ditto the evidence of Mr. Arthurian White.
Yes.
Right.
But those are black and white issues, but they only become black and white if one's able to establish the facts behind them. If the facts are...
This goes to the issue, to what issue does it? This is as to whether he did
It's
it.
whether he had a fair trial.
Well, yes, but
And whether he
talk
did,
about
and indeed whether he did
cross-examination.
it. Yes.
This is on the I didn't do it point.
Well-
This isn't the diminished responsibility.
Yeah.
This is I didn't do it.
Well, it's not a diminished responsibility. I mean,
The trouble of having these various cases, one I didn't do it, if I did do it, I was mad. That's
well, exactly. But unfortunately, one's never faced with a nice, tidy situation from which to build one's argument. And this is an absolute paradigm case where one hasn't got a nice, tidy situation from which to build one's argument. But I would suggest that one would be wrong to consider the diminished responsibility as that or nothing, if you like, because if his mental capacity was suspect, it may have been suspect, as it certainly was, it may have been suspect to an extent which would not ground a defence of diminished responsibility, but it may well have been something which the jury ought to have known about when it was deciding whether it was sure he possessed the necessary intent. Whether they were sure that...
Necessary intent?
Yes, because this was a case which was put not only on the basis of White's evidence that he appears to have had a gun, which he discharged, but also on the basis that he was party to a common design. So the jury were faced with a number of fairly important matters to consider, or a number of important matters to consider, in respect of which the fact that he was mentally unwell at the time would have been something that ought to have fed into their consideration of those issues. If they were asking themselves, are we sure that he intended to kill? Are we sure that he was party to a three-man attack on Burrow? Are we sure that he understood when the police were asking him questions? Are we sure that we can infer from the fact that matters were not put to Mr. Scott that he is lying about them now? All those matters are something which the jury, if they had known that he had been suffering from mental illness, might have decided in a different way. And one simply cannot rule those possibilities out.
I do apologise for asking yet a further question, but I just have to ask this one, I'm sorry. I quite understand that if Mr. White's evidence shouldn't have gone in, collapse the whole case, and that's perfectly straightforward. If White's evidence did go in, but if the judge had said, I'm withholding what the defendant said to the police, would that not have presented the position that there would have been no, the jury would have been deprived of his immediate answer to the police that I was not party to this murder? Well, because his statements to the police were actually a denial. They were exculpatory, although they involved an admission of presence. To actually withhold his exculpatory statement while putting in the evidence that he did it would itself have given rise to a legitimate complaint of unfair trial.
Well, it might have... I understand the point that your lordship is making, but there's a further point in relation to those statements. The judge directed the jury, and I'm no doubt that indeed the cross-examination was all on a lot of it was on the basis that you did tell the police these things, didn't you? And he said, no, I didn't. Those matters had not been put to Mr. Scott in cross-examination, so the judge commented to the jury in very strong terms about that. And no doubt the jury held it against Mr. Brown that he had not challenged the statements by the officer. If there had been evidence which the judge knew about that he was mentally unwell or had been mentally unwell, the judge might well have felt this is rather an unfair point for me to direct the jury about, that they should make an adverse inference against this man on the basis that certain matters weren't put on his behalf. For
In your
example,
client's cases, I did not do this. I can give a perfectly clear account. I did not do it. To introduce evidence to a jury that he's somebody who has in the past behaved aggressively, etc., would be a very dangerous thing to do, wouldn't it?
well, it might be, but on the other hand, if the jury knew that he was unable to give a good account of himself, or he could only give a less good account of himself than an ordinary, unafflicted person could do, that is a matter which they might have swayed them to a reasonable doubt in his favour. I mean, the fact is, my lord, all this speculation wouldn't be necessary if the information which the counsel, his counsel and the court should have had, if they had had it.
I'm awfully sorry, Mr. Custer, I'm still lost. What is it that Mr. Harrison should have done at the trial that he didn't do? Or alternatively, what is it that he did do that he shouldn't have done?
Well, he should have been in a position where he could consider
Yeah,
how
I've
to
got
run
all
the
that.
trial.
He should have had.
Yes.
He should have had the reports. But supposing he had, what should he have done that he didn't do?
Well, he should have inquired, first of all, as to whether his client was in a position to give him proper instructions
Got
and so
that.
forth.
Yes.
He should have raised the matter with the judge as to whether, in the circumstances, it was right that Mr. White's evidence should go before the jury.
I mean, he should have objected to it
He should have objected to it. He should have,
on the grounds that Mr. Brown,
on the grounds it was inadmissible under Section 34 of the Act.
and the reason why it was inadmissible was because of Mr. Brown's condition as at the date of committal.
Yes.
Got it?
Yes. He would have been in a stronger position in relation to the statement by Mr. Brown.
Sorry, what should he have, there's no good,
statement by Mr.
just
White.
saying that he'd have been in a stronger position.
Well-
What should he have done?
He should have objected to the witness statement of Mr. White going in as well,
I've got that, yes.
as well as the deposition. He should have.
And the witness statement.
Well, if he successfully objected to Mr. White's evidence going in,
But what's the basis of the objection to the witness statement?
well, in a sense, because the deposition went in, that is the way the trial proceeded.
Well, we know that, but
Yes.
what should have been the basis to the objection to the witness statement?
Well, it
because
would
there's
have
never
been-
been because there's never been a chance to cross-examine him
Yeah.
effectively.
Yeah.
Got it.
Yeah. And he would have been able to say, well, that's Section 34 of the provisions of Section 34 should not be overridden by.
Then something about the statement. Do you say he should have objected to Brown's interview with the police going in?
Well, if he had successfully objected to White's evidence going in, that would have been that anyway.
Precisely.
Yes. So he would have
Doesn't
had to do
arise.
that. So,
And
yes.
and therefore one only addresses the police interview on the hypothesis that White's evidence has gone in. Now, if White's evidence has gone in, is it your case that competent counsel ought to have been trying to keep the interview out?
Well, not necessarily, no.
Absolutely not.
But what he would also have been anxious to establish was that in the circumstances in which it was taken, it was unfair to make the subsequent points, as the judge did, that the inconsistencies in the manner in which it was taken were matters to be held against
Right.
my
So
client.
this is it. If White goes in, adduce evidence of the mental condition of the defendant to explain any inconsistency between it and his current evidence. Yes?
You said competent counsel should have done that. Would it not have been a very perilous thing to do? To introduce, if you're going to win on diminished, that's one thing, but to introduce weak diminished evidence to show that your client's got aggressive tendencies or has had in the past.
Well, I
when
don't
he's
think-
giving you a clear account, I didn't do it.
Yeah,
Are you saying that's something any competent
no,
counsel
but it
should have?
isn't
Sorry,
evidence
Mr. Gaffney. Question is, are you saying that's something which any competent counsel ought to have done?
But I'm not. You're putting the hypothesis to me that somehow by introducing evidence that he was aggressive in the past.
Well, once you put in his medical evidence, out it comes.
But there's very little evidence. There's evidence that there was one conviction in when was it, 1996. I mean, I don't see that. The really important part about his mental evidence would be that he didn't understand things.
Didn't the family take him to hospital and say that they had a 6-year history where he behaved in a paranoid and aggressive fashion?
Aggressive, violent, destructive, threatening people for the past 7 years. You can't have part of it, Mr. Gussie. You've got either some of it or none of it. That's 367, first entry, 1996. But anyway, I just want to be
But
uh,
I think the point that I was seeking to make is if competent counsel, if he had a patient who the judge knew, or if the judge, well, even if counsel didn't make the point, if the judge had known that this man was mentally incapable of understanding very much, he might very well himself have thought it's a bit unfair of me to invite the jury to infer that he must be lying because certain matters weren't put on his instructions.
So, fourth point, judge should not have summed up in the terms he did about the inconsistencies.
And indeed, it's perhaps unlikely that, well, it comes to the particular matters, but I'm very conscious of the time, and I don't want to exceed my estimate, but Section 34, which your lordships have that point, which is where I come to, of the Justice of the Peace Jurisdiction Act, under Divided 25, depends upon the accused having a full opportunity of cross-examining the witness. And if the accused is, on any view, unfit to plead at that stage, and that, of course, means that he is unable to give proper instructions to his counsel. So that must be what the jury found. Then Section 34 would not apply, so that the...
That would keep the deposition out, would it?
Yes.
What about the statement?
Well...
Is there a standard rule about the hearsay statements of dead witnesses?
There's a rule that they should not normally be excluded, but it's a matter for the discretion of the judge whether to exclude them or not. There's a case called Scott, which is, I think, in the bundle, in which was an identification case, which said that in ordinary circumstances they should be admitted, because that was the intention of Parliament. But there is always a discretion in the judge whether or not they should be admitted. And all I need to say, surely, is that in this case, the judge simply didn't have the material upon which he could exercise the discretion at all.
Yeah.
And it isn't, we would respectfully submit, entirely fair to say, well, it's more likely than not the judge would have admitted it, because one simply does not know at the... but if I can move on from the committal to remind your lordships that on the 19th of June, it was, so shortly thereafter, that he is indeed found unfit to plead by Dr. Otti, and that's at page 571. You've already seen that report.
Now, the committal was also in June, wasn't it?
The committal,
the evidence started in June. Yes.
Well, the actual evidence of Mr. White was given on the 17th of June. So this is... no, it's June 1999, the committal, my lady.
Yes, I know that.
Yes, but Dr. Otti is June 2000.
So it's not that close.
But on any sensible balance of probabilities assessment, it can be said with a fair degree of certainty that he was unfit to plead at the time of the committal, with respectfully say.
Have we got any record or reference to what happened by way of cross-examination of Mr. White at the committal, if any?
Yes, we have. His
Just
evidence
the
is at
page.
pages 130 to 133.
Yes, that's what I thought it was. Thank you very much. It is that bit.
And he was cross-examined. In fact, very often one finds there was no cross-examination at committal proceedings because defence keep their powder dry. But it was of a very curious issue arose because Mr. White was absolutely adamant
About the date.
Yeah. And he said it happened in November, and of course the death did not happen in November. And he stuck to this throughout the case, when he was cross-examined by another Mr. Harrison, I should emphasise this is not Mr. Harrison QC, page 132. I can't recall if I dated it. The date was 1 or 2 weeks in the month of November, and he continued to maintain, despite suggestions, that the incident happened in November, and he was asked a number of standard identification type questions, but he was not asked the question which was perhaps the most important identification question. He wasn't challenged as to whether he knew Romy, whether he knew Mr. Brown.
What was challenged, looking at 133, was that Romy was there at all. Is that right?
Well,
Line 16.
yes, but the question. Yes, he was challenged that he didn't see Romy that night.
Not there.
Yes, he said that he had done. But,
What was the suggestion then clarified? I'm putting it to you, you didn't see Romy with any gun that night.
well, I don't know whether that's clarification or simply repetition.
Yes.
I mean, one simply doesn't know.
Yes.
But if I took you to that in answer to my Lord
Yes, thank you very much.
question. Can I go immediately to the information we have as to the hearing of unfitness, because there's some documents as you must see as to that at page 575 of the record. This is the information that has been produced as a result of the request made by the board, or among the information that's been produced. Well, again, it's somewhat unsatisfactory. Page 575 is a note of a hearing before the Honourable Mr. Justice Record. I think Jamaican practice is to record witnesses, etc., on the back of an indictment, and this is really what we have. We have the witnesses, Mr. White, who was still alive at that stage, Mr. Scott, who was the detective constable in the case, and thirdly, Dr. Otti, and then after his name is evidence as to fitness of accused to plead. On the right-hand side of the list of the jurors, on the left-hand side, tried October the 31st, 2000, solely on issue of fitness to plead. Verdict: accused is unfit to plead, to be kept at the Governor-General's pleasure. Then the indictment is...
Who instituted the issue of whether he was fit to plead?
well, we don't know. This begs a number of questions. We don't know whether he was represented. We don't know who actually gave evidence, whether Mr. White gave evidence, whether Mr. Scott gave evidence, or whether it was simply Dr. Otti. Unfortunately, we don't have a transcript of the proceedings on that day, and the only light which is thrown on it is the unsatisfactory exchanges after sentence. And I suppose, the letter from the DPP. The consequences of the verdict, to begin with, must be that the jury was satisfied of the, if you like, the Pritchard elements of unfitness. So at that time, it would appear that we can infer, if I ask you to look at divider 17 of the authorities bundle, they're conveniently set out in a case called John M., a decision of the Court of Appeal here. The directions which were given by the judge in that case appear at paragraph 20 on page 897 of the electronic bundle.
I mean, was it being argued that he was fit to plead?
Well, apparently not.
Your case is that he was unfit,
Yes.
Guthrie, so we really don't need to spend any time on that issue, do we?
No, except
Your whole case is that he was unfit.
but what it means, of course, is that he was incapable of understanding or found to be understanding the charges, deciding whether to plead guilty or not, exercising his right to challenge jurors,
Yes.
instructing solicitors and counsel, following the course of proceedings,
Yes.
and giving evidence in his own defence. And your lordship referred to Pritchard, but it is a heavy,
Exactly.
it's a heavy disability to be found to be under.
Yes.
And then the jury, having made that finding, the question is what happened, so to speak, to satisfactorily allow him to be tried in 2003?
Now, is there a premise to that question? Is it your submission that once a jury has reached a finding of unfitness to plead, there cannot be a trial and arraignment without the impanelling of another jury to determine the question of current fitness?
Yes, well, that would seem to be the position.
Well, have you any authority to support that?
Well, the exact question, we haven't been able to find a case on exactly the same facts. We submit that it is necessary there must be at least some judicial determination of fitness to plead, which there was not in this case. And the answer
Have you any authority?
the question that your lordships asked was,
Yes.
in what sense was he found fit to plead? And the short answer is
No,
he
that
wasn't.
wasn't the question I asked. The question I asked was when...
I would say the question your lordships asked following the application for special leave. I come to your lordship's question.
Right.
The position, we were asked, what circumstances was he found fit to plead? Well, he wasn't found fit to plead. I mean, that is the answer to your lordship's question. Whether I would suggest that question really reflects one's instinct that if a jury finds someone unfit to plead, it is not possible for the executive then simply to put him on trial.
That is the position in English law now, isn't it?
Well, I'm not sure, my lady, because we have the case of Hazani in the bundle, which suggests that it's not. Certainly, I'm not quarrelling with the proposition that someone can't get better and be tried. The question is what safeguards need to be in place before that is permitted.
And the DPP's letter clearly says there need be no jury determination of fitness.
Well-
you don't accept that.
Well, I don't think...
But what's your ammunition?
Well, the Lords, the position, we know that there is a jury finding in October 2000. The laws are now changed in Jamaica, of course, as I think you know, and I don't think I need go to all the new provisions. But the law is different in England too. But in England, it would be necessary for there to be an intervening stage at which the procedure is gone through to, if you like, make sure that the jury's verdict is reconsidered. In England, it's not the jury anymore. But if I ask you to look at the case of Hazani, you will see It's a divider 13. In the case of the Court of Appeal, it became a judicial review case. What had happened was the question of law is set out in paragraph 2 at page 852. If an accused person is found to be unfit to plead under section 4, but becomes fit to plead before he is dealt with under section 5, talk about the 1964 Act, is the court necessarily required to follow the procedures in section 4A and 5? It was found that they didn't, but at paragraph 15, the decision to retry was quashed because there had been no second procedure under section 4. This is paragraph 15. It is important that the procedure be followed, even though the outcome seems clear. Having quashed the order, we remit the case back with the direction to hold a second section 4 hearing. Now, if you translate into the Jamaican circumstances, one looks at tab 26 to see what the law is in Jamaica. It's the relevant section is on page 1039 of the electronic bundle.
Sorry, what number was that again?
1039.
Thank you.
That, as has been pointed out, is taken from the 1800 Act.
Yes.
Yes.
Yeah.
Now, have you done any research to see, under the 1800 Act in England, what was the customary procedure?
We have done our best to find something which would assist, but we haven't been able to find it.
I mean, the best I've done, I'll let you have it over the short German if it helps, is in Pritchard they cited a judgment of Miss Justice Park in Dyson where he quoted a section from Hale, which doesn't suggest that there had to be a fresh judicial determination once a person had become apparently well, but it doesn't say that doesn't have to be either. But one's looking to see, therefore, whether there was an established practice in English law which required a judicial determination in circumstances where somebody appeared to have become fit to be tried and there didn't appear to be any current issue.
Well,
your research has led you nowhere on that.
well, we haven't got any further now.
No.
If one looks at the wording of section 25 of the Act, which you have at page 1039, it follows, we would respectfully submit, from what the Act says. If any person indicted for any offence shall be insane, and shall upon arraignment be found so to be by a jury, lawfully impanelled for that purpose, so that such person cannot be tried upon such indictment. So the effect of the jury's verdict is that the person cannot be tried upon that indictment. And something surely must happen judicially, not just the letter of a doctor, to say that that verdict is no longer to stand.
And I'm not sure that does necessarily follow, because the test whether somebody is capable of being tried on indictment is the Pritchard test, isn't it, which had over the centuries come to be developed. And the question is, so the jury is impaneled to decide whether the Pritchard test is made good. It's not the jury which makes him unfit, it's the jury acknowledging that his mental state makes him unfit. Now, when he has then made an apparent recovery, and all the doctors agree he's made a recovery, the question is whether procedurally there has to be a fresh hearing. And I don't see that one gets that at the moment out of the language of section 25.
Well, if the effect of the verdict is that he cannot be tried, then something must surely happen to show that he can be tried. And if one postulates a situation where an executive disagrees with the jury's verdict and finds a psychiatrist who says, well, actually, I don't think they're right at all. I think it's perfectly okay. We're going to try him tomorrow. That seems to me, with respect, to be driving a coach and horses
Well, it
through
would.
the whole of the procedure.
Of course it would. But what would happen, Mr. Guthrie, is that if the psychiatrist, if the prosecution then listed it again for trial, saying, here's a report which says he's fit to plead, the defence either accept it or they don't. And if they don't, there is another trial of the issue.
Well, my Lord, that didn't happen.
Wait a minute, isn't it as simple as that? If they do accept it, then there doesn't need to be a further trial of the issue.
Surely, at the very least, the judge who is to try the trial of the person must be aware of the fact of the jury's earlier verdict.
Mr. Guthrie,
In this case, Mr.
there were
Justice
seven,
Pitter
I think there were 7 interlocutory applications in the months leading up to the substantive trial. Isn't this where Mr. Justice Carl Harrison comes in?
Well,
the prosecution, let me just finish. The prosecution shows him the leverage report. It says he is now fit to plead. Mr. Harrison gets up and says, I'm not very happy about that. I wonder whether your lordship should order a second report. Mr. Justice Carl Harrison says, yes, Mr. Harrison. Then we get the Otte report. And then, because that confirms fitness to plead, the decision is made, the trial should go ahead.
Well, my lord, all I can say is, your lordship's asked for the information. We have done our utmost to get the information. My learned friend has done the utmost to get the information. We have no idea what was said at any such interlocutory application. And for your lordships now to say, well, it must have been this or it must have been that, is simply not the way in which this appeal should be disposed of.
Anyway, if your procedural point is right, if there has to be a jury impanelling, then even if the result would inevitably have been a finding, you are entitled to say, well, there just hasn't been a proper trial, period.
That's exactly what happened in the Hazani case, which is, if you will recall, I just took you to, the Court of Appeal said, well, even if it was a formality, then it must take place, and we quashed the decision because it did not.
Yeah.
But I do respectfully suggest that the procedure for finding of unfitness has to be seen as providing a serious safeguard for the defendant, in that his mental state will be examined and considered. And to say that safeguard, so to speak, comes to an end with the moment of the jury's verdict that he's unfit to plead and can be set aside without some proper evidence of a judicial determination or a judicial acceptance on the part of the defence that it is not necessary, or something of that nature, which there certainly was not in this case, because we know that Mr. Justice Pitter, who tried this man, did not know about it. And there's no indication, there's certainly no certainty that Delano Harrison QC knew about it. All that we know he knew of was that there had been mental troubles in the past, and that it was considered by the doctors that he, well, at the sentencing stage, not before, that he had the report. So, my lords, I've said I don't want to overstate my case, but surely at its minimum, I can say that.
Now you are out of your allotted time, Mr.
Well, I'm very sorry.
But I'm very conscious that you've spent a lot of time responding to questions from the bench.
Well, in fact, most of the questions have meant that I have covered, I think, almost all the ground that I need to cover. I am...
Can I ask you a question?
Yes, of course.
Is there, I mean, there's obvious evidence that for many years leading up to 1997, the appellant was being treated for chronic schizophrenia, wasn't very compliant with his medication, but was being prescribed medication. We've, of course, got plenty of evidence that if he takes his medication, which he has been doing since he's been in custody, possibly unsurprisingly, he recovers really quite dramatically, the difference in his presentation between the two. Is there any evidence at all that he was prescribed any medication between the last note of the prescriptions in the Bellevue Hospital and when he is arrested for the offence and is...
I think I've taken you to the last entries in the notes that we have.
Well, is the answer to my question no?
Yes, I think so.
Well, that's rather important, isn't it?
Well, there must, on the view, be a suspicion that all was not well in September 1998 with him, and that he was mentally ill at that time. There must be more than a suspicion.
Of course, a chronic schizophrenic whose illness is controlled by medication is still mentally ill.
He's still mentally ill, but there's no indication that he was controlled by medication at the time. And we know that immediately afterwards he was very definitely not, because I took you, I think, to the entry on page 370, which said that he...
Well, the reason I'm putting this to you, and it is intended to be helpful, Mr. Guthrie, unlike quite a lot of the questions that have been put to you, is there's a very clear account given by Dr. Goulburn in the letter on 579.
Yes.
This is from Bellevue Hospital. And it's to the court, the gun court, and it says, the above patient has been treated at this institution for psychotic disorder complicated by cannabis abuse, last recorded treatment in September 1997.
Well, I'm extremely
Consisted
grateful.
of Modicate injection, blah, de, blah, de, blah. In other words, quite a heavy medication programme. Was previously treated at the University Hospital for approximately 6 years. So that is the record that we have of his contact with the psychiatric services in Jamaica up to September 1997, and we do know the state that he was in 98, 99.
I'm extremely grateful to you, but we also know, my lady, that...
That's actually the last entry.
No, I don't think that's right. But my own friend Mr. Perrington says that if paragraph 18 of the
374, isn't it?
page 374 is the last entry, which is the one which I had misread as 92, but is in fact 18.
That's right, that's in November, yes.
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 Yeah.
But we also know...
This is indicating something, but probably the medication which we have mentioned on 373, prescribed in September, and then he's seen in November not too well.
Yes, and indeed, not only that, but shortly after the alleged offence, we can see that he has really quite extreme symptoms. And it isn't nothing that the magistrate, whenever he came in front of her, sent him straight to the psychiatric ward. I think it's the only occasion I've seen this happen in Jamaica, certainly, where there are limited facilities. But quite plainly, he was seriously mentally ill, and the symptoms that he reported over the notes appear to be much the same. Voices, hallucinations, and so forth. I'm very worried that I haven't yet.
Yes, what have you not done that you must do?
Well, I've got to do sentence.
Yes.
Because I think I probably have to briefly address the effect of a successful appeal against conviction. We have an up-to-date medical report, but I think we can hand it in. What it says is that he is now perfectly well, provided he takes his medication. But he still has to do that.
But if your earlier submissions are right, the effect of allowing appeal would either it means the whole conviction is quashed full stop, or it gets returned for a trial of the issue of his fitness to plead.
Yes, I would...
Is that correct? I mean,
well,
I'm very bothered by this concentration on fitness to plead.
yeah.
Whereas I think, speaking entirely for myself, the real issues are what was his mental state at the time of the offence, was Mr. White's evidence properly tested given his probable lack of fitness to plead at the time, and what should have been the treatment of his own statements to the police. Those seem to be much more crucial issues, and wouldn't necessarily say go back for a trial of fitness to plead, but would say go back for a trial.
But would it not be go back for consideration whether, after all this time, the interests of justice require a trial?
Yes, indeed.
I would put it in that way, my Lord. If your lordships are with me on the points which would lead to his conviction being set aside, I would respectfully submit that that would be the appropriate order to make, to return the matter to the Court of Appeal. But there are doubts with respect as to whether or not the original verdict of the jury that he was unfit to plead would simply be restored, because he's been in custody now as the result of the verdict of the jury in the other case, and the result of the sentence which was passed on him by the judge in January 2003. But
Would you like to say a few words about sentence?
yes, I would. There's, of course, there's a limited concession in any event as to the start date, which the Court of Appeal thought should be April, but plainly should have been January. There's a broader point. The first is, perhaps I can just tell you that the legislation in Jamaica for the start date of a sentence is the same as that being considered in Ali and Tiwari. Yeah. It's the Judicature Appellate Jurisdiction Act, which we can put in separately if it's not in the bundle. But in any event, it's exactly the same terms as your lordships considered in a case called Ali and Tiwari, which is at divider 2 of the bundle of authorities. There is, however, a broader point in that we say that the question of sentence ought to be remitted in any event. We say the judge's approach, which I took you to at the outset of the appeal, that, well, he didn't seem to be labouring under any mental difficulty on the evidence that I heard, is too simplistic an approach. And we say in our case, the judge isn't to be blamed for something which did take him by surprise, but it wouldn't be right to say that the evidence that he was reacting to being disrespected was somehow inconsistent with serious mental disability, which is the approach the judge seems to have taken. The further point, we say the judge, if you like, started from a mistaken appreciation of the position. There's a further point as to the approach to be made with regard for the allowance for time spent in custody. If I can just give you the times concerned, as you know, the alleged murder was on the 22nd of September 1998, the murder by someone. He was arrested on the 30th of September, so he's been in custody since that time, which is just over 17 years ago. There was then he was then in custody until he was found I'm sorry, Lord, I've got a rogue reference now. The dates concerned. He was tried, yes. So he was found unfit to plead just over 2 years after he was first in custody. That was the 30th of October 2000. And he was tried in January 2003, just over 4 years and 3 months in custody at that point. And the appeal was dismissed on the 11th of March 2005, but I don't think anything turns on that. So far as your lordships have delivered authority on how time before trial and before conviction should be taken into account, we have included in the bundle the main cases. I think I only need ask you to refer to Ducky at this stage, which is under divider 1.
So what was the total period of time that he'd been in custody prior to sentence?
Prior to sentence, he had been in prison for
4 years, 3
4
months.
years and 3 months.
Yep.
Does that omit the period while after the unfit to plead, or does it?
No, that's inclusive.
Includes the whole area.
It was I think I gave you that figure. He was found to have unfit to plead just over 2 years after he was arrested. It was 30th of October 2000, and he'd been in custody since the 30th of September 1998, so 2 years and 1 month.
Part of it's in prison and part of it's in hospital,
No,
presumably.
it's all in prison, isn't it?
It's all in prison until he's found unfit to plead.
Until he's found out.
And was he transferred to hospital after being found unfit to plead? We don't know that, do we? I have no indication that he was.
I think there's a problem in Jamaica because I don't think that there's a hospital.
So there may not be.
Because I've been involved in another case recently, which
Yes,
in fact was abandoned, I think.
That's right. There was an appeal to us abandoned on the basis that it
Yes,
wasn't
I was going to
doing any good.
respond to that appeal,
Yeah.
but I think that my opponents took the view that he was being better looked after in prison than he would be if he was succeeded and
Yeah.
released into.
This all goes to the earliest possible date for consideration of release. doesn't it?
Yes.
Yeah.
Yes. Well, we submit that the whole of the period that he was in custody should be taken into account. And we do that really on the authority of
Of course, the judge did say in a general way, well, I'm going to take that into account. Is that permissible?
Well, no, he should have explained what he meant when he said that. A good sentencing practice, I think, always it involves explaining the basis of the calculation. We don't know whether he did take it into account in the overall figure or not. Or we don't know precisely what he took into account, which is one reason why I say that the question of sentence would have to go back in any event. But in the authority of Dookie, you'll find under Divider 1, the discussion begins at paragraph 11. And that's a reference to Ali and Tiwari, which is the case you have at Divider 2. The making of orders backdating sentences to the date of conviction should not be restricted to exceptional cases.
Sorry, could you give me a number for that?
Page 695, maybe.
Thank you.
That dealt, first of all, with time pending appeal. But if I take you to the second sentence of paragraph 12, the real question arising here is how to deal with the 14 months earlier spent by the appellant in custody awaiting trial. This question, as to the proper approach to time spent in custody awaiting trial, was considered by the board in Kalachand and the state. The following passages from Sir Paul Kennedy's judgment for the board are now in point. That case is separately within the bundle at Divider 5. But I quote from it here: the board is not concerned in the present case with time spent by a person in custody as an appellant. So their lordships need not consider the need to deter frivolous appeals, but they are concerned with the basic right to liberty. In principle, it seems to be clear that where a person is suspected of having committed an offence, is taken into custody and subsequently convicted, the sentence imposed should be the sentence that is appropriate for the offence. Seems to be clear, too, that any time spent in custody prior to sentencing should be taken fully into account, not simply by means of a form of words, but by means of an arithmetical deduction when assessing the length of the sentence that is to be served from the date of sentencing. We find it difficult to believe that the conditions which apply to prisoners held in remand in Mauritius are so much less onerous than those which apply to those who have been sentenced, and that time spent in custody should not be taken fully into account. If that is thought to be the position, there should be clear guidance as to the extent to which time spent prior to sentence should not be taken fully into account because of the difference between the prison conditions, etc. And that should be considered by the Supreme Court. There may be unusual cases where a defendant has deliberately delayed proceedings. Lord, we say that in the present case, well, I think perhaps I should also read paragraph 15 of the judgment. There was an attempt by the Mauritian courts to mitigate its full effect, which I don't think I need to trouble you with, but at paragraph 15, the lordships confess to some difficulty when one comes to analyse the differences in the conditions imposed respectively on remand prisoners and convicted prisoners. These really seem to amount to very little, certainly compared to the altogether graver conditions which they have in common: the loss of liberty in the denoted identical physical conditions, the right to wear one's own clothing, etc. These are minor benefits indeed compared to the fundamental fact of confinement.
Are you asking us to do any more than to remit it so that the Court of Appeal can consider what the Jamaican practice is as to time in custody pending trial?
Well, I would ask.
You want us to say
I would
all
ask
that?
you to say that in the circumstances of this case, there would be no reason not to deduct the whole of the period that he spent in custody from.
Well, what is the Jamaican practice? Do we know?
Well, I mean,
Everybody knows that that's the English practice, but that's because it's in the statute.
yes,
In case, isn't there?
I would. I hesitate to
No, all right, well, don't
say
worry.
it, but I think I probably can give you some assistance in a moment, and maybe Mr. Full can. That was what I had, I think, left.
Well, if there's anything more you want to say to us on that, you can say it in due course. Yes. Mr. Pennington-Benton, do you want to? Mr. Poole.
My lady, my lords, the course I proceed to take is to deal with conviction first, which are the issues 1 to 5 as set out in the statement of facts and issues, which is page 594 of the paper record and the electronic record, and then deal fairly briefly with the issues on sentence, which are issues 6 to 8 in the statement of facts and issues. Hopefully, in the time left before the short adjournment, though, what I propose to do before dealing with the conviction points is to make some brief observations on the evidence and the facts of the case. I will attempt to follow the course that's set out in the written case for the respondent. And if I can first ask the board to turn to paragraph 14 of that written case and specifically deal with my Lady Hale's last question, Mr. Guthrie, really about the appellant's medical history. Because I think there is some confusion. I think, in fact, Dr. Goldborn hasn't got it quite right in the letter that's at 579. So I just want to make good that point by reference to some documents in the bundle. What I've sought to do at paragraph 14 of the written case is set out, in addition to the points that are made in the chronology, some of the key entries that shed some light on the appellant's medical history leading up to the date of the offence, and then the last reference in the medical reports after the offence itself. So we start with the entry on the 19th of August 1996, and the reference to that is at 371. With 371, these are Bellevue Hospital records, and this is the treatment chart. And so we can see from the entry at the very top of that page that on the 19th of August 1996, the appellant was receiving treatment for his condition. And then when one turns back one page, which is a copy of the nurse's notes, we can see an entry at the bottom of the page for the 2nd of September 1996 that records patient came to A&R, was treated at A&R recently, good effect, returned follow-up to be seen by MO, medical officer, re-meds review. So we have reference there to receiving treatment and it had a good effect, which I accept is not contentious. We then move to entries, if I may, on the 24th of September 1997. And if we can, at this stage, go to Dr. Goldborn's letter, which the board has already seen, which is 579. And what Dr. Goldborn records here, as Lady Hale has second sentence, last recorded treatment in September 1997 consisted of, and then the board may already have this information at its disposal, but a Modicate injection, which is a treatment for acute symptoms of schizophrenia, chlorpromazine, which is an antipsychotic, and then 2 other drugs that are referred to, cogentin and artane. They are drugs to control and assist with muscle tremors and stiffness as a consequence of taking antipsychotic medication.
Well, don't we have the treatment sheet on 371?
My lady, you're ahead of me. We do, and at 371 you have the entry for September. The additional point, which is I was going to make, which is why I say that
Yes.
Dr. Goldborn is not quite right, is the point that if you look at 374, you have an entry for the 18th of November 1997, and I do say, for the avoidance of any doubt, it is 97 following the chronology and other documents. And here, there's an assessment of the progress notes as stable, which is the fifth line down on that entry. There is then the line underneath it, Plan C, what looks like chart.
RX, it's the, is it prescription?
Sorry,
It's like, it will be prescription, yeah.
yes, and the entry that the board has not yet gone to.
Then we go to the bottom
Turn
of-
back to the treatment chart.
Yes, I know, and there obviously was a prescription in November.
Absolutely.
There
And
clearly was, yes.
just to link the two up, it's not clear. I think the numbers on the left-hand margin have been cut off. But if in the body of that last entry, in the treatment column, we see a date 18/11/97 and a similar medication as to that referred to above and Dr. Goldborn.
So your point is the bottom entry on 371 appears to indicate an active prescription in November 97.
It does. What we don't have, and I readily accept that, is that we don't have anything following that entry on the 18th of November 97 up to the date of the offence, because the next, well, if I put it this way, the first entry after the offence is the 21st of October 1998, and the reference to that is at 581.
But before we get to that, last recorded treatment, September 1997, yes, absolutely. But then the first entry on 374 is an October consultation, not compliant remedication. So we've got a problem there about his not taking the medication. And then, as you point out, the following month, there's a further prescription.
Well, yes, and I suppose all I'd add there is I accept in October there's an issue that he's not taking it. When we then skip forward a month to 18th November, the assessment, what I rely on there is the assessment made at that stage is stable. And then one looks at what has been prescribed. And in fact, I mean, we know the Modicate is an injection, so he would have, whilst he might have been left...
And we have no evidence of any prescription, any treatment from the prescription in November 97.
No. And as I say, the first entry we then pick up in the medical notes is the 21st of October 98. That's the reference that included the reference to malingering at 5.
Well, that's when he's brought in after the event.
So I readily accept there's a year that's unaccounted for, but I say it's precisely that lack of contemporaneous medical evidence as to the appellant's mental state at the time of the offence that makes it even more important to look at the facts and circumstances of the case. And as was said in the case of Walton, which we might go to probably after the short adjournment, you look at the nature of the killing, the conduct of the appellant before, at the time of, and after. And the board may recall the case of Robinson that was before it a few months ago, that I think all members of the board, perhaps save for Lord Woodson, were on. That was a case of diminished responsibilities. And it has striking similarities to the facts of this case. In the case of Robinson, the appellant had a history of mental illness, very similar to the history here, in fact, very similar diagnosis date and age at the time, and suffered from schizophrenia. There was then a year prior to the offence that was unaccounted for. There was no evidence that he was taking his medication. But what you had in Robinson, that when we looked at the case later, was, in my submission, extremely important for the defence of diminished responsibility to be raised at all, was that there was evidence of destitution, the appellant in that case living a destitute lifestyle for the 12 months leading up to the offence, even though he was a man of, he had education, he had family behind him. He lived a destitute lifestyle, and there were very peculiar actions, both at the time of the offence and immediately after the offence. And I say, if one, obviously every case turns on its own facts, but if one was to, in contradistinction to the facts of Robinson, when one looks at the facts here, we don't have those elements. Those are observations then on the appellant's medical history. With one eye on the time, I'm happy to make some further observations just on the facts, but at the same time, I don't want to eat into anyone's lunchtime.
According to my computer, you've 3 more minutes.
Well, my lady, I will make some headway, if I may. Then. Returning then to the written case of the respondent, at paragraph 6, what I've sought to do there is respond to the direct question that was asked in the letter from the registrar. 6A, it's not controversial. There was a finding of unfixed plead. But over the page at 6B, what I've sought to do there is set out, again by reference and giving references that I won't go through now, to the contemporaneous medical records from the prison. The evidence that I say shows precisely why the appellant was fit to plead and stand trial in January 2003. Because as well as the reports that you have from Dr. Leveridge and Dr. Otti, what you can see from the contemporaneous medical records is steady improvement that starts, if one looks at little b Roman 1, with the entry on the 23rd of November 2000, where there's a record of the appellant being much improved. And then, if I can ask the board to, there's a reference that needs to be really inserted between Roman 1 and Roman 2 chronologically, and it's an entry for the 23rd of March 2001, and the reference is at page 498. And that is, in fact, the first recorded entry of fitness to plead. And if one turns up 498, it's the last entry on 498, 23rd of March 2001. I won't attempt to read the first 2 lines, but when below the first 2 lines, one then sees the letters FTP, fit to plead, and then underneath court report to be done. And that is in fact picked up by Dr. Sewell, and all may recall seeing Dr. Sewell interviewed and examined in August 2014. And his report appears at 453, and just really to cross-refer to that entry, at page 454, when dealing with the past psychiatric history, Dr. Sewell records, available medical records indicate being regularly evaluated since being incarcerated in April 2000. He was first declared fit to plead on March 23, 2001. So that's as it were, a missing reference, I think, from both.
Sorry, which page is that on?
That's on 454, and it's just before it's about 8 lines up from the bottom of that page, just before the bullet point list.
Yes, I see.
And that's
Sure, yeah.
498. And as I say, that's just an omission from the chronology, which I apologise for, but also little b on page 650. Perhaps I wasn't going to descend too far into the debate about the third report and whether we are missing a report, although I perhaps have nailed my colours slightly to the mast by footnote 4 on page 650. But I accept, perhaps all I would say is, and I don't disagree with Lord Toulson's suggestion that in fact, the third report could very well be the report of Dr. Otti. I suppose all I would add, and I think it's a point that Mr. Guthrie made, is there's a reference in the transcript to both Dr. Leveridge and Dr. Otti reporting again, which is obviously consistent with Dr. Otti preparing 2 reports, but we've only got one report.
The reference was to them both examining again, which is not actually necessarily the same as reporting.
I accept that one. It may well be that it was the third examination that didn't produce
Or third joint examination is the point.
that produced the Dr. Otti report.
Precisely.
I accept that.
Well, that seems a very fine extra point to have got in your... Actually, it's now 5 minutes that you've had, but we will look forward to hearing from you further at 2 o'clock.